Yeah. You see, I just woke up.
He's been sleeping in the back of the van possibly for the past 5 hours.
Do you know where he lives?
He's gonna show me, but he said he wants to warm up first.
Yeah. Thank you.
What's that? Well, I would say I would.
2 o'clock. How his mother has left him?
What if he's allergic to something here?
Oh,
Yeah.
How's it going?
sorry.
Oh, it's okay.
Good.
That's good. Yeah.
You're not allergic to nothing.
You sure?
Yeah, are you sure, buddy? Because a lot of people are allergic to something. Is that fine? Okay. I'll come back and get more of that.
The black car.
Thank you.
Thank you so much. Put up real quick, buddy. My car. My car's right over here, okay?
Do SROs have contact or access to their stuff at home or whatever? I'm not sure.
I may have to use you because you got a car with some.
You need a car seat?
You know,
Do SROs have access to their stuff at home?
they do. What school you go to, brother?
So Lincoln will be the south side.
Alright, let me close the door. I'll turn the heat on for you, okay? The only problem I have with putting him in the backseat of your squad is I want him up front to show me where he lives. But I don't want to have him up front. We'll figure this out.
What's he saying?
He woke up in his mom's car. You guys said he came from that way. Can you head that way and see if there's a car door that's open? He woke up in mom's car and he was alone. The car was turned off.
Maybe your mom's name, Soundex something?
Oh my god.
Okay.
I'll be right behind you.
You say you go to Lincoln? Okay.
You know what? We'll go ahead and I'll ride with you. Yep, that's right. Right, buddy? I think we're gonna go to zone 1.
Zone 1?
Yeah, we're just gonna go across the street. Are we gonna go this way, bud? Okay. All right, buddy. We're gonna need your help. You gotta look out the windows and tell us which way to go, okay?
The boy began to give directions to the police. He told them that his house was near a building with a flame sign and that his mother's car was a silver Dodge Journey. The police drove slowly through the apartment complex. Red and blue lights reflected off the damp pavement, and every turn was dark and silent.
You live over here in these apartment buildings here?
No. You go in there.
Okay.
Okay.
You're looking. Oh, my mom's cars are so. And
Let's try to remember where mom's car is at.
it's at that dude with the fire song on it.
It's over there by the store with the fire sign on it.
Do you know what color mom's car is?
Silver.
Silver. Okay.
He says it's a truck. That's what he knows it is.
Okay.
This one here. This one's not mom's, is it?
It is.
This one's mom's? That's mom's car?
It was locked. This front door was. This doesn't look familiar.
My apartment is across.
In that building right behind us.
Here, I'll tell you what, pull up the screen. Okay. Ah, there we go. Hi.
Hey,
He's saying this doesn't look familiar. He said it's across the street.
over there. The plate came back here though.
The plate, she's in house and she comes back here.
Now, what apartment?
See your door number as well. But it's not here.
We got a call through at 104 on the 28th of January.
There's a different one.
On Spiros?
here.
That says 858.
Yeah.
So let's go to 858. I'll walk over there.
All right, Dan. I'll be right back. Okay, bud.
What's up, buddy?
Like
You want which window? This one? Oh, you cold? Yep, no problem, buddy.
Oh. Hey, long time no see. Sorry. We got a little kid here, and we're looking for his mom, and she used to live in 102. That's why I was knocking. Where's he live at?
Across the street.
Okay, we're going over there. We're trying to make contact with mom. Last house was right there, so that's why I was knocking. So, yeah, he's like 6 years old. I don't know. That's what we're gonna find out.
Is the building to your left? Is that where mom stays?
no.
No. So is the building to your right where mom stays? Is that your home? No. Okay.
Oh, she lives over there, but just in that apartment.
She lives in that apartment over there, in the big building to her left. Okay. Then you think your door number is 104? Okay.
Actually, he just found my apartment.
I just found your apartment.
What's that?
I'm getting someone to call.
Where's she
Hello,
live?
how you doing?
Good. How's it
I
going?
don't know where she lives.
You know where she lives? Okay.
Last thing I knew was across the street.
Okay, yeah. That's where her registration comes back to. Saw that they don't live there. He said he lives across the street.
Well, that's what the guy that lives in 102 said.
Yeah.
He's the guy in the wheelchair. That
Yeah.
lives around. He said that she lives across the street, so he thought it was this building.
No, he's right. He's fine to come here.
I gotta give him to Shay. You guys are trying to call her right now?
Alright.
Do you have a phone number just in case I can't get a hold of her? In case we can't find her right now, I need to have a phone number. Can I get that from you guys?
You know you can get possessed by candy?
Possessed? How so?
Because if you like it too much and you smell it, you might put your eyes out. Don't eat it.
It's your first time eating this week? When was the last time you ate?
I ate many times, but not this time.
Okay. Many times, but not this time?
Why would her car be up there? Was it warm? Almost makes you want to go over and look at the video at 7-Eleven and see how long it was. I don't know if we'd see it. Maybe Thursdays we would, but
That's supposed to keep that camera up there.
Is Troy your brother?
Yeah, he's 17.
He's 17. Okay.
Wait, how do you know that?
I'm just I can look stuff up on my computer. I found brother in house there at 857-102. When was the last time you saw mommy?
I remember seeing her when I wasn't asleep.
Okay. Do you remember where you were? So you were in the parking lot with the flame on the building. Does that sound right?
Mm-hmm.
Okay. And that's the last time you saw mommy when you were awake?
Mm-hmm.
Okay.
What's going on?
Check.
Yeah. You see, I just woke up.
Damien said up in a car that was turned off.
What?
When the police knocked on the door of an apartment across the street, a middle-aged woman opened the door, looking tired and surprised to see a child being held by an officer. She quickly realized it was her son, and her face showed confusion and fear.
You got a son, Damien?
He was in my car?
Yeah.
What the f?
Who was in your car last?
I was.
When was this?
What? He was just But I could have sworn he was just here. Call Uncle Frog. They said they just talked to him in the wheelchair. We told him that he stayed for them. Y'all talked to my uncle? Yeah, he told them that he stayed. I thought he was. Let me get my coat.
We're bringing him right over here. He's just across the street.
He at Uncle Frog's house?
No, he's in our squad right now.
He ain't your squad car?
Yeah.
Come on.
He's coming in.
We're bringing him to you.
Okay.
What kind of candy you got? Kit Kat? Yeah.
No.
So, when's the last time you were in your car?
I was in my car. What time is it? It's what?
3.
Yeah. Almost 3 in the morning.
2:45.
The last time I was in my car, I came back from Walmart. That was like 10. Yeah, my uncle came over here and everything.
Was he with you?
Yes, we went to a fun night and then I went to go get something to eat and then we went to Walmart and I came back. Where you been at? You was in my You fell asleep or something?
Yes.
I could have sworn he came in with the other kids. I pulled everything out the car, pulled one of my kids out the bag. I don't even remember not being in the house. Huh?
You got back here at 10 o'clock?
Yeah, and I pulled up right here and let all my kids out. If he was asleep in my car, I wouldn't have.
Which car is this?
It's a Dodge Journey. I
So the
parked
one that is parked across the way?
at the quick start. Yeah, that's my car.
So you pulled up, dropped all the kids off here?
Yeah, and then I went and parked my car. Me and my daughter parked the car and we walked up over here. And I went in the back and went to sleep.
Okay. Yeah, he was at 7-Eleven for about 10 minutes before they
At
called us.
7-Eleven.
Yeah, he wasn't house anybody. He said he woke up, he was all alone, and he was cold.
This is who was in the car with me.
Okay.
So you can this is my daughter.
Who was sitting next to him?
I don't know, I got stuff all in my car. And y'all, I had my 3 little kids in the back and she was in the front seat.
Okay.
But y'all can ask her because she was just knocked out.
You saw him walk in with you? Coming back from school?
Yeah, because we went to school.
Okay. And where did you go after that?
Where we go before we came here? Oh, no, we went to Walmart.
Okay.
And then we came.
Do you remember seeing him get out of the car? Huh?
10-4, not even.
Okay. Well, we're gonna have to check the cameras. I believe that there's gonna be some surveillance cameras that,
Stop, it's not parked my car.
well, yeah, their seats will reach all the way over there, 7-Eleven. But you don't remember him coming in?
I don't remember seeing her myself come in. I just assumed that all my kids was in that house because I've never knocked out them all out of the car before. So,
Yeah.
and And then by me running in and out with the stuff, I just assumed that he got out the car. I didn't know he was still asleep in my car.
Yeah.
And then we all was in the house. My uncle even came over here and everything. I had no idea. Everybody, when I asked where the boys were, everybody said they was in the house asleep already. So.
Okay. All right. I don't know what the outcome of this is going to be. There's a potential that you could be charged with endangering the health of a child, even that he's been sleeping in the back of a van possibly for the past 5 hours.
In the back seat of my car, my back of my trunk has boxes, these moving boxes in the back of my trunk.
Okay. I get that. I'm just saying that's a potential, okay? I do have to notify DCFS of what happened tonight, so they'll probably be in touch with you. Is this a good address for you right now? Okay. All right, I'll be in touch with you, okay?
All right, thank you for bringing my boy to me.
No problem. Yeah, no problem. All right, thanks, Shay. Her car is right here.
That car?
Yeah, the car that he came out of. It's parked right here. I'm not gonna be able to see it. Do you want me to come back and pay for that Kit Kat? I don't have my.
No,
Are you sure?
I want to pay because he was crying.
Are you sure?
So yeah, I'm sure. Because I want to buy for him because he was crying. So then you reminded me, oh, don't give anything which is allergic.
Yeah. Thank you.
Thank you.
Shawnee, great. You want to leave all your property with her? You're going to be in and out in like 10 minutes. Completely up to you. I got to search you when you get in here. You really don't need anything. You want to just leave your coat with her then? Again, you're going to be in and out. April 14th, 9 o'clock in the morning over in Sycamore is where you need to go. This is what you were charged with. So that's yours. I need 2 signatures from you. Stating that you are going to comply with the stipulations of bond. Can't leave the state of Illinois without permission of the court. You got to give written notice to the clerk of the court of any change of address within 24 hours of such change, and you can't break any more laws while you're out on bond. If you do that, they could revoke your bond and you can be charged with violation of bail bond. Okay?
I don't have any record. I don't have anything prior to traffic. I don't have any cases with DCFS. I've never had a problem. I have 9 kids and I've always had my children. For my son to not get out the car and get under a blanket and me to see other coats in the house is ridiculous. To say that I saw the look on his face, any child in that situation would have had a look of panic in their face. But to say I felt something for that child and then to charge me, and I've never been convicted of anything, is redundant to me. It's really stupid because now things are going to get harder. And if you really cared about my kids and how the situation went, why put me a charge when I've never even been in trouble?
Do you want to read what the complaint says?
I don't even
It's
care
clear
at
as
this
day.
point. I have no choice.
Frost clung to car windows, sidewalks glittered with thin ice, and the streets were almost completely empty. At 2:05 in the morning, under the harsh fluorescent glow of a 7-Eleven storefront, a barefoot child pushed open the glass door and stepped inside. No jacket, no shoes, no adult following behind him. Just a small boy, alone in the cold, searching for warmth. The night shift employee noticed him immediately. A child this young should not be walking alone at 2 in the morning, let alone in freezing temperatures. The boy's skin was red from the cold. His thin shirt offered no insulation. He asked if he could stand inside for a moment to warm up. The employee, concerned and unsure of the situation, allowed him inside and picked up the phone to call 911. Within minutes, a patrol unit arrived. When the officers entered the store, they were met with a scene that would raise immediate alarm for any first responder. A young boy standing near the counter, hands tucked under his arms for warmth. No guardian in sight. The officer knelt down to his level, speaking gently, establishing trust. The child explained that he had woken up alone in his mother's car. The car was turned off. No one else was there. He said he got out because he was cold. That single sentence changed everything. A child waking up alone in a car at night is not just a welfare concern. Under Illinois law, it immediately triggers a potential child endangerment investigation. When a minor is left unsupervised in a vehicle in dangerous weather conditions, Police are required to treat the situation as a possible criminal neglect case until proven otherwise. At this stage, the officers were no longer simply helping a lost child. They were beginning the early steps of a legal inquiry. The first priority, however, was safety. The boy needed warmth, reassurance, and protection. The officer offered him food, asked about allergies, and spoke calmly. Establishing rapport with a child witness is crucial. Children can become confused, frightened, or uncooperative if questioned harshly. Officers are trained to ask simple, non-leading questions to gather information without influencing responses. The boy stated he knew where his mother's car was parked. He described a silver Dodge Journey and mentioned a building with a flame sign nearby. The officers decided to let him guide them, but another legal and procedural issue emerged: transporting a minor without a proper child seat. Policy often requires officers to take precautions when placing a child in a squad car. They improvised carefully, ensuring the child was secure while still allowing him to point directions. As they drove slowly through the apartment complex, red and blue lights reflected off damp pavement. The child pointed out turns, scanning the dark rows of buildings. Eventually, he identified a silver vehicle parked near a building. The officers approached it. The car was locked. No adult inside, no sign that anyone had checked on it in hours. At this point, the officers were documenting potential evidence: a parked vehicle, a missing caregiver, a child found alone in freezing conditions. Each element contributes to a legal standard known as reasonable suspicion that neglect may have occurred. The officers now had enough grounds to continue deeper investigation. The next step was locating the parent or guardian. They asked the child where he lived. He pointed toward an apartment building. The officers knocked on doors, speaking with residents. A neighbor recognized the description and pointed them across the street. Slowly, they pieced together fragments of information: names, prior addresses, family connections. This is typical of welfare checks involving minors. Officers rely on community knowledge, registration records, and witness statements to locate guardians as quickly as possible. Eventually, a woman opened the door of an apartment across the street. When she saw the officer holding the boy's hand, confusion washed over her face, then fear, then realization. It was her son. The officer stepped inside to speak with her. The mother appeared shocked. She claimed she believed all of her children had exited the car earlier that night. She stated she had returned from Walmart around 10 p.m., unloaded the children, brought groceries inside, and assumed the boy had come in with the others. She said she did not realize he had fallen asleep in the car and remained there for hours. From a human perspective, her explanation may sound like a tragic oversight. From a legal perspective, it required careful evaluation. Illinois child welfare statutes do not require intent to harm for an endangerment charge. Negligence alone, failing to ensure a child's safety, can meet the threshold for criminal liability if the risk created was substantial. Leaving a child unattended in a vehicle overnight in freezing temperatures qualifies as a potentially life-threatening environment. Whether intentional or accidental, the legal system treats the resulting danger as serious. The officers began documenting statements. They asked when she last saw the boy. They asked who else was in the car. They asked whether anyone verified that all children exited the vehicle. They noted the time gap, from 10 p.m. until after 2 a.m. That meant the child could have been alone in the cold car for nearly 5 hours. They also considered another factor. The boy had walked to the 7-Eleven by himself. That meant he was not only left unattended, but had been exposed to additional dangers: traffic, strangers, freezing temperatures, while seeking warmth. Each of these risks compounds the severity of the situation under child endangerment law. At this stage, the officers were balancing two responsibilities: compassion for a family in crisis and duty to enforce child protection statutes. Police in such cases must notify the Department of Children and Family Services. This is mandatory reporting. Once DCFS is alerted, an independent investigation begins to determine whether the child can safely remain in the home or whether protective measures are necessary. The mother repeatedly stated she had never been in trouble before. No criminal history, no prior DCFS cases, multiple children in her care. She insisted this was a mistake, not abuse. These details matter later in court. but they do not negate the immediate duty of officers to document and forward the case. The officers explained the potential charge, endangering the health or safety of a child. They informed her that the matter would be reviewed by prosecutors and DCFS. They explained court procedures, bond conditions, and upcoming hearings. Throughout, the mother expressed disbelief that she could face charges despite claiming no malicious intent. This moment illustrates a core principle in child protection law. Intent is not required to establish neglect. The law focuses on outcome and risk, not just motive. A caregiver's duty is to ensure a child is accounted for at all times, especially in dangerous environments. Failure to meet that duty, even accidentally, can result in criminal liability. By the time the officers left, the situation had shifted from a missing child welfare check to a formal neglect case under state supervision. The boy was returned to the home under DCFS oversight. The mother was issued legal documentation outlining the charges and court date. A system designed to protect children had now been set in motion, and all of it began with a barefoot child walking into a convenience store at 2:05 a.m., asking simply to warm up. Hours after the initial welfare check, the legal machinery surrounding the incident continued to move quietly but relentlessly. Cases involving unattended children in extreme environmental conditions trigger automatic reporting protocols. Once officers file their report, it is transmitted to both the local prosecutor's office and the Department of Children and Family Services. From that moment forward, the situation is no longer simply a parenting mistake handled with a warning. It becomes a recorded child endangerment investigation with permanent documentation. To understand why, it is important to look at how the law defines risk to a child. Under Illinois statute, a caregiver commits child endangerment when they knowingly or negligently place a child in circumstances that endanger their life or health. The statute does not require injury. It does not require intent. It only requires that a reasonable adult should have understood the danger. A car in near freezing temperatures, engine off, no blankets, no supervision, for hours, that meets the threshold. From a legal standpoint, the key element here is the duration. If the child had been alone for 5 minutes, the situation might have resulted in a stern warning and a safety plan. 5 hours in freezing temperatures crosses into criminal negligence territory. Prolonged exposure to cold can cause hypothermia. Hypothermia in children develops faster than in adults. The law treats that risk as potentially lethal. This is why officers on scene repeatedly asked the mother to reconstruct her timeline. When did she park the car? When did she unload the children? When did she last physically see the boy? Each answer locked in a window of time. Every minute added weight to the probable cause for endangerment. The mother's explanation that she assumed all children exited the vehicle is common in these cases. Large families, late nights, exhaustion, distractions. But assumption is precisely what neglect law addresses. Caregivers are required to confirm, not assume. In court, a prosecutor would frame it simply: a responsible adult must account for every child in their care. Failure to verify is failure of duty. Another critical element was the child's independent journey to the 7-Eleven. This introduced a secondary risk factor: exposure to environmental and stranger danger. Child endangerment law considers not only the initial risk, the car, but any subsequent hazards created by the initial neglect. Once the boy left the vehicle, he became vulnerable to traffic accidents, abduction, or further exposure to cold. The chain of risk remains linked to the caregiver's original failure to supervise. When officers returned the boy to the residence, they did so under a temporary safety resolution. Returning a child does not mean a case is closed. It means authorities have determined there is no immediate life-threatening danger at that moment. DCFS then conducts follow-up visits, interviews other children, inspects the living environment, and determines whether further protective action is necessary. The family enters a monitored status until the investigation concludes. The mother's visible distress during questioning is another pattern common in neglect cases. Many parents in these situations are not malicious. They are overwhelmed, exhausted, managing multiple responsibilities. But the law is structured around objective standards, not emotional explanations. A judge does not evaluate whether a parent feels regret. The judge evaluates whether the environment created met the statutory definition of danger. The mother repeatedly emphasized she had no prior record. That matters for sentencing, not for determining whether the offense occurred. In first-time neglect cases where no physical injury occurs, courts often allow supervised release, parenting classes, or probation rather than jail. But the charge itself remains serious because it establishes a documented incident in the family's record. Any future reports will be weighed against this history. From the child's perspective, the interview process is handled with special care. Children in welfare incidents are not treated as suspects. They're treated as protected witnesses. Officers ask neutral questions. Where did you wake up? Were you cold? Did anyone tell you to stay in the car? They avoid suggesting blame. Their goal is to gather facts without shaping testimony. Everything the boy said that night, waking up alone, being cold, leaving the car, became part of the official record. Another important legal factor is the absence of physical injury. The boy was cold and frightened but not hospitalized. This distinction likely prevented an escalation to aggravated child endangerment charges. Had the child suffered hypothermia, frostbite, or required medical intervention, the charge severity would increase. The law scales punishment based on harm outcome, not only risk creation. Still, the absence of injury does not erase criminal liability. The statute recognizes that waiting for harm to occur defeats the purpose of child protection. The offense is creating the dangerous condition in the first place. After documentation, officers issued the mother a notice to appear in court. This is standard procedure in nonviolent child endangerment cases, where there's no immediate risk of flight or continued danger. She was informed of court dates, bond conditions, and restrictions. These include mandatory court appearance, notification of address changes, and compliance with DCFS directives. Her frustration at being charged, despite no malicious intent, reflects a common misunderstanding of negligence law. Criminal negligence exists precisely to address situations where dangerous outcomes arise from inattention rather than cruelty. Society places heightened responsibility on caregivers because children cannot protect themselves. The law therefore imposes higher accountability. Meanwhile, DCFS would open an administrative case. Social workers review the police report, interview household members, evaluate sleeping arrangements, check for adequate food, clothing, and supervision. They may require parenting education courses, periodic check-ins, or temporary safety plans. Their goal is prevention of recurrence rather than punishment. The intersection between criminal court and family services is important here. Even if a criminal charge is eventually reduced or dismissed, DCFS findings can still remain on record. These records can affect custody arrangements, future employment in childcare fields, and future investigations. The consequences extend beyond the courtroom. This case also highlights how modern surveillance indirectly supports child welfare enforcement. The 7-Eleven security camera provided objective time-stamped evidence. It confirmed the child entered alone. It established the time window. Video evidence removes ambiguity and strengthens prosecutorial confidence. Without it, the timeline might rely solely on recollection. With it, the facts become fixed. From a policing standpoint, the officers followed standard protocol: secure the child, locate guardian, assess environment, document statements, notify DCFS, issue charge documentation. Every step is guided by policy manuals designed to balance compassion with statutory duty. Failure to report would expose the department to liability if future harm occurred. By sunrise, the emergency aspect of the incident had ended. The child was safe. The mother was informed. The system had engaged. But legally, the case was only beginning. Court proceedings, social service oversight, and possible long-term family monitoring would follow. And at the center of it all remained one simple truth. A child woke up alone in the cold, and the law exists specifically to ensure that never happens twice. In the days that follow incidents like this, life often appears to return to normal on the surface. The child goes back to school. The parent goes back to work. The apartment lights turn off at night, just like they always have. But beneath that surface, an invisible process has begun. Case numbers exist. Reports are filed. A social services file now bears the family's name. and a court date sits on a calendar that will determine what happens next. From the court's perspective, this case is not about a single mistake. It is about whether the conditions that allowed the mistake to happen still exist. Judges in child endangerment hearings ask specific questions. Does the caregiver understand what went wrong? Have steps been taken to ensure it cannot happen again? Are there support systems in place? Is there evidence of a pattern, or is this an isolated lapse? Because the mother in this case had no prior record and no evidence of intentional harm, the legal system is likely to treat this as negligent endangerment rather than malicious abuse. That distinction matters. Malicious abuse implies intent to harm. Negligent endangerment implies failure to protect. Both are serious, but the law responds differently. The likely outcome in cases like this is a combination of court supervision and child welfare oversight. Parenting classes, scheduled home visits, mandatory check-ins, proof that safety measures have been implemented. The court's goal is not simply to punish, but to ensure the environment that led to the incident is corrected. But even when custody is retained and jail time is avoided, the record remains. If another incident occurs in the future, even something minor, the system will remember this night. That is why first incidents carry so much weight. They establish a documented baseline of concern. From the child's standpoint, the long-term impact is harder to measure. Children rarely articulate fear the way adults do, but experiences like waking up alone in the cold, wandering unfamiliar streets, being questioned by police in the back of a squad car, these moments imprint quietly. They become part of a child's understanding of safety and trust. That is why child welfare law prioritizes prevention over reaction. The officers who handled this situation did more than return a lost child. They activated a protective network designed to keep that child from facing the same danger again. This is the part of policing rarely shown in headlines, the slow procedural work of safeguarding children when harm was narrowly avoided. And for the mother, this incident becomes a turning point, not because she intended harm, not because she was malicious, but because the law demands a higher standard when a child's life is involved. Fatigue, distraction, stress, these are human. But when they place a child in danger, the consequences become legal, not just personal. In the end, this case is not defined by villainy. It is defined by vulnerability. A child too young to protect himself, a parent stretched thin. A system designed to intervene before tragedy occurs instead of after. If you were the passerby who first noticed a small barefoot child in the freezing night, would you have stopped? If you were the store clerk who saw him walk through those doors alone, would you have called for help? And if you were the parent who realized, hours later, that a child had been left behind without you knowing, how would you carry that weight? Because sometimes, the difference between a tragedy and a second chance is simply the moment someone chooses to act.